Okay, that's the federal court system. Now we also have a state court system. In the state court system, there's essentially three levels: the magistrate, the district, and the Supreme Court. Okay, within them, they will mostly have an original and an appellate jurisdiction as well, right? So we need to go through and it gets a little bit confusing. But the idea here, well, of course the magistrates won't, but have an appellate jurisdiction. But from here we can start to see how the appeal system flows for areas like contract, crim, and areas where the state has the power to make the law. So the first thing to note is that the High Court is at the top of the state court hierarchy. So it's that unifying court between the federal and the state court systems. The second thing to note is that the levels of court, like the Supreme Court, has two jurisdictions: the original jurisdiction and an appellate. The district court has an appellate jurisdiction and an original jurisdiction. The Magistrates Court only has the original jurisdiction. Now, the rough rule of thumb is that as you go up the hierarchy, right, the importance of the case increases. So it will be worth more commercially. So you'll hear matters worth more money in the district court than the Magistrates Court, and more money in the Supreme Court original jurisdiction, right? So the importance, or the crime it'll be a worse crime the higher up you go in the court system. And we'll come to what the levels are in a minute. But just conceptually, that's what's going on. As you go up the court hierarchy in the original jurisdiction, the matters become more weighty, more important, more impactful in society. And we can also see how we can appeal. So if you're not happy with a decision that happens, there are various avenues of appeal to a higher court, either within a hierarchy, like from the Supreme Court to the Court of Appeal, to the full court of the Supreme Court, or between courts, so from the District Court to the Supreme Court, because it's higher in the hierarchy. So let's just have a little bit more detail on that. The Supreme Court is the highest court in the state hierarchy, and it has a trial division, which is first instance, and a Court of Appeal, right, the appellate jurisdiction. In the original jurisdiction, the trial division hears both civil and criminal matters. The trial division hears the most serious criminal cases, things like murder, manslaughter, major drug trials. Generally, you'll get a jury used to decide whether the defendant is guilty or not guilty. In terms of civil matters, it's got to be worth more than $750,000, $750,000. So it's a major commercial issue. Most civil cases are heard by a judge alone. Okay. The Supreme Court also has that appellate jurisdiction, and that's called the Court of Appeal. It hears all the appeals for the Supreme and District Courts and many tribunals. It often consists of 3 to 5 judges. So another term that you may come across is that of jury. So in certain trials, there may be a jury who's a group of ordinary citizens, and they concentrate on the questions of fact. So the judge determines questions of law, and the jury determines questions of fact. So there's quite this division when we do have a jury. Most times that you have a jury, it will be a criminal matter that's being heard for the first time. And traditionally, jury decisions needed to be unanimous. The idea being, if you couldn't get everyone to agree that someone had done something, say murder, then there was still the possibility of reasonable doubt. And you'll remember from back across here that the standard of proof in criminal matters was beyond reasonable doubt. So if someone couldn't agree to it, then there was a reasonable doubt. That was the idea behind having a unanimous jury verdict. However, we've amended the law. The law has been amended such that for trials other than murder, the judge can see if a verdict can be reached from 11 out of 12 jurors. So we don't need a unanimous for non-murder trials anymore. 11 out of 12 could still lead to a guilty verdict. that juries are used in some civil claims, things like defamation. Generally, you'll see that there's a jury of about 4, a lot fewer number on a jury for a civil issue, and they're not used very extensively because it's so expensive. It also is possible to have judge-only trials. While either side can apply, the accused person must consent. So the accused person always has the right to have a jury trial. When might you have a judge-only trial? When it's complex or lengthy, so it would be burdensome to the jury, or really particularly where there's been pre-trial publicity, where the accused might think that they can't get a jury that's unbiased. They might opt for a judge-only trial. Again, we won't spend too much time on that. It's more of a thing to recognise rather than learn. Okay, the next court that we have is the District Court. It has an original jurisdiction. So civil claims between $150,000 and $750,000 are heard in the District Court. So remember, the Supreme Court is above this and the Magistrates Court is below this. So this is how we know which court to go to, right? If the trial is for damages of $200,000, it's going to go to the District Court. The District Court in a criminal jurisdiction handles moderately serious criminal matters. You can have a jury for some of the more serious moderate criminal matters and a few civil claims with procedures the same as in the Supreme Court. There is an appellate jurisdiction where a district court judge can hear an appeal from the decision of the Magistrates Court. Okay, so the final court in our state system is the Magistrates Court. Criminally, they hear minor offences like shoplifting, traffic offences. Civil matters, they can hear civil matters for the amount less than $150,000. They do play another important role in committal proceedings. So when there's a serious crime like murder, the magistrate first hears the state's evidence to determine whether or not there's sufficient evidence to justify a trial. So what they're doing is saying, is there enough evidence for someone to go to trial? Why do they do that? Because if you didn't do that, then the state might charge someone and the trial might not happen for a year or two, and the person could languish in jail without any real evidence at all. So a committal proceeding is where they're brought before the court to see if they have a case to answer. Okay, so does it justify a criminal trial? Magistrates courts do that as well. Okay, so that's the majority of the court systems that we have in Australia. Well, our state system and the federal system of courts that we have. There's one other kind of area we want to cover in terms of the judicial arm of government, and that's tribunals. Okay, so we're just going to do 2 tribunals to give us an idea about what tribunals are and what they do. So let's have a look at that. So sometimes a statute or a law can establish a body to regulate specific areas. So what's happened is that there's become too many cases for our court system, and we need some form of specialised body who can settle disputes. What we have is the idea of tribunals. Tribunals offer quicker, cheaper, and easier ways to solve disputes than courts. Parties can represent themselves and the process is less formal. So it's more efficient and it's more open to people as a dispute resolution mechanism. Here are the 2 tribunals we want to cover in the course: QCAT, the Queensland Civil and Administrative Tribunal, and the AAT, the Commonwealth Administrative Appeals Tribunal. So QCAT looks at matters like tenancy disputes, debt disputes, consumer and trader disputes. So really, if it's less than or equal to $25,000, you'll be looking at going to QCAT in terms of these areas of dispute. So an unpaid invoice, wages owing, and that way you can bring that matter before this tribunal to get it settled without incurring huge legal and court costs to get a resolution. The AAT, the Administrative Appeals Tribunal, is about when we have disputes involving a Commonwealth government department, including ministers and statutory bodies. So it reviews decisions if an act or regulation specifically provides that it's the body to review it. At the moment, around 400 acts and regulations give the Administrative Appeals Tribunal the right to review those decisions, areas like tax, social security, immigration and citizenship. So that's the body who reviews government department decisions around these areas. So we don't have to go to court again, a much efficient, open and effective mechanism to try and resolve those disputes. Wow, that was a lot about the judicial arm, and I know that that's a long video, but hopefully we've got the kind of basic building blocks. We've got one more video to go looking at some court procedures, and after that we've gotten over the real hump about the basic building blocks of our legal system, and we can start to see in more detail how it actually works.